All right, welcome everybody. Thank you so much for joining us today. As always, I do want to start by introducing myself. Oop, there we go. My name is Adina Glincher, and I am the Senior HR Services Advisor here at PayEntry. I am not an attorney, nor is our team, so if you have any questions for your legal team, we do ask that you reach out to them directly. However, for any questions at all about the content of the training or about our HR services offerings here at PayEntry, please do feel free to reach out to us at hrservices@payentry.com. You will see that email address as well on the last slide. And you can always submit your questions into the question box on your screen, and we should have some time for a quick Q&A session at the end. So feel free to do that, and we'll address as many of those questions as we can. All right, so why are we here today? Today we're going to be discussing employee classifications. And we purposely left that pretty broad because there are a lot of classifications we want to cover. And as always, these webinars are meant for general information. If you want more information on any one of these topics or you have specific questions related to your industry, reach out to us directly and we can absolutely provide you with some resources. So we're going to talk about how you're classifying your employees. Are they full-time or are they part-time? Maybe both. Exempt versus non-exempt. We're going to discuss some FLSA exemptions. We're going to cover interns and volunteers and the difference between them, as well as independent contractors. We're also going to touch on temporary and seasonal employees and what the difference between the two are. And then we'll go over a few common misconceptions, and as mentioned, we will end with a Q&A session. So how are you classifying your employees? As I'm sure you know, employee classification is not a one-size-fits-all approach. Employees are generally classified based on the following factors. So the number of hours they're scheduled to work, are they full-time or are they part-time? The expected duration of the job, so is it a temporary or seasonal position or regular? And then their job duties and salary threshold, which will determine if they're exempt or non-exempt. And before we get any further, I want to mention that we do have these slides in the handout section of this GoToWebinar platform. So if you want to go ahead and download those, feel free to do so. This way you can refer back to them. Some of the slides have a lot of information today, so we want to make sure you have a copy. So feel free to download that. So the first thing we're going to discuss is full-time versus part-time. The Department of Labor and the Fair Labor Standards Act do not actually define full-time or part-time employment. And what do we mean by that? This is a common question we get from our clients is, how do I know how many hours my employees need to work to be classified as full-time? Well, the answer is it's up to you as the employer. You get to define how many hours your employees need to work to be classified as full-time and how many hours they need to work to be classified as part-time. And our HR advisors are always happy to give you recommendations on what those numbers should look like, but there's no federal or state law that gives you an exact number you need to follow, excuse me. However, there are some federal and state laws that define full-time and part-time employment for the purpose of compliance within that law. So for example, the Affordable Care Act, as many of you may know as ACA, applies to employers with 50 or more employees, according to the IRS. Now, the IRS identifies a full-time employee as someone who, on average, completes at least 30 hours of service per week or 130 hours per month. So what does this mean? This means that in order to qualify as a full-time employee under the ACA, you need to work 30 hours or more per week or 130 per month. Now, as an employer, you can still decide that full-time from an internal benefit standpoint is higher than that 30 hours. Maybe you want to make it 32 or 35. But if you do have 50 or more full-time employees, according to the IRS standard, it may be easier to avoid confusion to just also have your full-time threshold as 30 hours. So we could absolutely talk more in detail if you have questions related to that, but there are some state and federal laws that have specific requirements. Qualifications and eligibility for benefits are usually different between full-time and part-time based on hourly requirements, and we're talking about some internal benefits and health benefits. And then certain states and local jurisdictions require employers to provide paid sick leave to all employees regardless of status. The next topic we want to discuss is exempt versus not exempt. And if you've ever reached out to us with a question, you have probably heard us mention this. It's definitely something that is talked about a lot in the HR world. Now, what is an exempt employee? An exempt employee is exempt from the FLSA requirements, such as minimum wage and overtime. Typically, they must be paid a salary above a certain level, which is determined by federal or state law. And they must qualify under one of the specified exceptions, including but not limited to administrative, professional, executive, computer, or outside sales. And we'll get into those some more on the next slide. And then the Department of Labor, as well as some states, actually have a duties test that can help employers determine who meets this exemption criteria. If you're not sure if your employee should be classified as exempt or non-exempt, definitely reach out and we can provide a sample duties test as part of our service so you can help identify what the appropriate classification is. A non-exempt employee is protected under the Fair Labor Standards Act. What does that mean? They are entitled to minimum wage and they're entitled to overtime. And then there are state laws that may have their own labor law requirements. Of course, if the state law is more gracious to the employee, that's the one you need to cover. And from a conservative standpoint, it is always best to classify your employees as non-exempt because this way they would qualify for minimum wage, overtime, meal break requirements than it is to classify them as exempt. So if you're not sure, our recommendation is generally to go with non-exempt, but if you would like us to help you figure that out, definitely reach out. So as promised, we're going to dig into these FLSA exemptions a little bit more. I mentioned a duties test. What does this look like? A duties test is based on an employee's actual job duties, hence the name, not their job title or job description. All the requirements of the test must be met in order for employees to be exempt. And some of these exemptions include executive, administrative, learned and creative professional, highly compensated, and outside sales. Now you might be thinking, well, aren't your job duties what is described in your job description? And yes, that would be ideal, but we just like to definitely note that even if your job description says something completely different, this test needs to be done based on the duties your employee is actually doing. Salary basis. What is this? It's important that your employees, in order to qualify for an exemption, regularly receive the same amount on payday, regardless of their hours worked. They cannot be docked for hours not worked in a day, and unless there are a few exceptions to that. And the salary basis must be at least $684 per week. Some states may have their own salary threshold requirements to keep in mind. So it's important that you check your state threshold to make sure they are qualifying. There are some other FLSA exemptions we're just going to touch on here. So learners, apprentices, messengers, students employed in agriculture, and full-time students employed at institutions of higher education may also be exempt. And this is not one of the common talked about exemptions. Learners and apprentices may be paid a sub-minimum wage, but only if the wage hour administrator finds that lower rates are necessary to prevent curtailment of opportunities for employment. For learners and apprentices, this finding must apply to the industry, not to a particular worksite or employer. Messenger and/or learner certificates may be issued for a period no longer than 1 year, and each special apprentice certificate must specify the conditions and limitations under which it is granted, which includes the periods of time during which sub-minimum wage rates may be paid under a registered apprenticeship program. I know that was a lot. If you have questions related to this, or you think you may have employees who qualify for this exemption, let us know and we can dig into this a little bit further with you. All right, so there's a lot of information on this slide, which is why we ask that you do print out that handout so you can come back and refer to it. But we really wanted to focus on interns and volunteers on these next two slides because these are common questions we get asked. Can we hire interns? Can we bring on volunteers? Do we need to pay them? So we're going to address a lot of those questions here. So there's a difference between learners and apprentices, which we talked about on the last slide, and interns, which sometimes are called trainees. Courts have used the primary beneficiary test to determine whether an intern or student is in fact an employee under the FLSA. If an internship meets all of the below requirements, the intern wouldn't be entitled to minimum wage, overtime, and other FLSA protection. So let's review some of these together. The first one, the extent to which the intern and the employer clearly understand that there is no expectation of compensation and are not entitled to a paid job at the conclusion of the internship. And this is often why we encourage that there's work permits involved with the employee if it's legally required, if the intern is still in school, and that there's a clear internship letter or some type of documentation in place that outlines all of this. Next, the extent to which the internship provides training that would be similar to that which would be given in an educational environment. The extent to which the internship is tied to the intern's formal education program by integrated coursework or the receipt of academic credit. I know a lot of times some colleges and universities allow students to actually get credits for participating in certain internships, so that would qualify. The extent to which the internship accommodates the intern's academic commitments by corresponding to the academic calendar, the extent to which the internship's duration is limited to the period in which the internship provides the intern with beneficial learning, and then the last one, which I personally believe is one of the most important, the extent to which the intern's work complements rather than displaces the work of paid employees while providing significant educational benefits to the intern. So not only does this internship need to educationally benefit the intern, but they should not be doing the same work as your employees. They should be doing work that complements the work of the business. So that is if they're doing the same work as your employees, then they're likely need to be covered under the FLSA. Now we're going to jump over to volunteers, which have some similar requirements. So the FLSA does recognize the generosity and public benefits of volunteering and allows individuals to freely volunteer in many circumstances for charitable and public purposes. You may volunteer time to religious, charitable, civic, humanitarian, or similar nonprofit organizations as a public service and not be covered by the FLSA. Individuals generally may not, however, volunteer in commercial activities run by a nonprofit organization such as a gift shop. Generally, a volunteer will not be considered an employee for FLSA purposes if the individual volunteers freely without contemplation or receipt of compensation. Typically, volunteers serve on a part-time basis and do not displace regular employed workers or perform work that would otherwise be performed by regular employees. So that's definitely something we just talked about on the intern slide too. They should not be doing the same thing your employees are doing. And paid employees of a nonprofit organization cannot volunteer to provide the same type of service to their nonprofit organization that they are employed to provide. It's very important that the duties are different for employees versus volunteers and interns. All right, the next big one we want to talk about today is independent contractors. And a couple reasons we want to touch on this. First, we get a lot of questions on it. And second, a lot of states and the federal government are really cracking down on this classification. And we'll get into the reasons why at the end of the slide. So contract employees or independent contractors are individuals hired for a specific project or a certain time frame for a set fee. They're often hired to do their expertise in a particular area. They're usually hired for projects that require a short-term project rather than a full-time, long-term employee with expertise. These individuals are classified differently than internal employees by the IRS for tax purposes. So they will receive a 1099 tax form rather than a W-2 tax form. And they typically do not receive benefits like health insurance and time off or any other company provided benefit. So those last two bullets are a big reason why regulatory agencies are really cracking down on this. One, tax purposes, right? We want to make sure people are filing their taxes accurately, correctly, and that everybody who's supposed to get a piece of the pie is getting that piece. Secondly, the benefits. A lot of employers are under the impression that if they just call somebody an independent contractor, they don't have to worry about benefits. And that is not the case. You can't just call somebody an independent contractor and not pay them benefits. They must actually qualify, and there is absolutely a liability in place if they are misclassified because they will be owed all these benefits or wages or whatnot. So it's important that this is clearly classified within your organization. Now, what makes an independent contractor independent? A worker is presumed to be an employee unless the individual meets certain requirements under federal and state law. So I'm going to pause right there. When we talked about the exempt versus non-exempt slide, I mentioned that from a conservative standpoint, if you have no idea how to classify your employee, then non-exempt is the conservative classification, the one we would recommend. When it comes to independent contractor and employees, same thing. If you don't know how to classify them, an employee is the safest way to do so, generally, because then they qualify for your benefits and for tax purposes. However, the best thing to do is to classify them correctly. So if you don't know whether or not your independent contractors are true independent contractors, definitely reach out to an attorney or reach out to our team, and we can definitely help guide you to whether or not they're classified correctly. Now, the most common test is the IRS Common Law Test. The IRS Common Law Test has three broad categories to help with this classification. The first is behavioral control. It examines whether the company has the authority to direct and control the work of the service provider and looks at whether the worker receives training and instruction. Second, financial control. It looks at factors such as whether the worker realizes a profit or loss, makes investments in tools and facilities, and has unreimbursed expenses. And lastly, the type of relationship. So they will dig in and examine the nature of the relationship. This includes whether there is a written contract between the parties, the permanency of the relationship, and whether the worker is entitled to any employee benefit. An employer must weigh all factors and take into account other applicable tests. In addition, the employer should look at the entire relationship, consider the degree of control, and make sure that you're documenting each of the factors used in making a determination. Now, this is important because if you're ever audited and there's a question in place as to whether or not people are classified correctly, it is important that you have documentation to show how you came to the decision you came to, and that you've already done the test to prove that they are indeed an independent contractor or are indeed an employee. And the Department of Labor, the Equal Employment Opportunity Commission, and several states also have independent contractor tests, as well as some states have more strict requirements. So it's important that we're looking at our state requirements, of course. If one or more of the following statements is true, the individual is in all probability an employee. So the employer requires compliance with instructions as to when, where, and how the work is to be performed. The employer provides formal or informal training. The worker is a part of the business operations. The greater the business success is dependent upon the worker, the less likely they can be classified as an independent contractor, The employer has an interest in the methods used to accomplish results. The employer can hire, supervise, and pay other individuals to assist this worker. The employer sets hours for the worker. The worker devotes most of their working time to the employer's business, and the employer furnishes a significant amount of the tools, materials, and/or equipment used by the worker. When in doubt, it is best practice to classify the worker as an employee, which we already discussed. All right, our next big topic, temporary versus seasonal employees. Temporary employees are typically hired to fill gaps in business workforce during peak seasons or when an employee is on a leave of absence. You can hire a temp or a temporary employee on your own or through a staffing agency. They can be classified as full-time or part-time, depending on their hours worked. And the Department of Labor states that a temporary job is a job that lasts less than 12 months. Anything after that must be treated as a long-term employee with the appropriate rights and benefits. Now, very similar, but there are some slight differences in a seasonal employee. Seasonal employees are typically hired during a particular season, hence the name, to keep up with the business demand. Often, businesses like retail, sales, and shipping companies need to hire seasonal employees during the holidays or during other peak time. Usually, they're hired on a part-time basis, but not always, and they generally work irregular hours. And employees work for a specific period of time during a specific season, and generally for 6 months or less. Now, best practices when it comes to temporary and seasonal employees. First and foremost, they are employees despite how long they are working for you. So make sure that you are complying with the FLSA when it comes to minimum wage, overtime, and classifying employees as exempt or non-exempt. Make sure you are clearly defining expectations regarding the duration of employment, both verbally and in writing. Communication is always key. Make sure you're providing mandatory benefits such as state-mandated paid sick leave. Be aware of predictive scheduling laws that require employers to give employees advance notice of their work schedules. All of the usual employment laws, such as prohibiting discrimination, harassment, and retaliation, will apply. And make sure that you're developing written policies and procedures for temporary and seasonal employees so they are aware of their rights and any benefits that they qualify for. All right, so we're just going to review some common misconceptions, and we put this together based on many of the things we see with our clients or many of the questions we get. So a big one is assuming that all employees paid by salary are exempt from overtime. Generally, when somebody comes onto our service, we ask, hey, how many exempt employees do you have and how many non-exempt employees do you have? And we often get questions about what do those terms mean. And a lot of people assume it's salary versus hourly. And although that's often used to describe exempt versus non-exempt, you may have a salaried non-exempt employee. So that's not always the case. It's important that you know whether or not your employees are exempt, and that's not whether they're based on, that's not whether they're paid salary or hourly. Another one is assuming employees paid above the exempt salary threshold can be classified as exempt. So just because they make a certain amount of money doesn't automatically mean they're exempt. There are job duties to consider. Improperly applying an exemption or documenting how an employee qualifies for an exemption. Treating an employee as an independent contractor or an independent contractor as an employee. Confusing federal and state laws. This is a big one as well. State laws apply when the state law is more generous to the employee. So we're always going to look to see which one is more generous and apply that one. And then having a job description is wonderful, but if it doesn't accurately reflect what the employee does, then it makes it very difficult on many levels, right, to do a job duties test, also for the employee to know what the expectations are. So it's important that your job descriptions actually reflect what your employee is doing. So here are some consequences of employee misclassification. Of course, wage, tax, and employment violations will result in fines and back pay. There may be tax and payroll fines. You may owe back pay to the state and federal government based on taxes, Social Security, Medicare, and state unemployment. There may be penalties for failing to deposit payroll taxes and fines for not having I-9 forms on record. There may be legal and punitive damages and ongoing lawsuits. And back payments to reclassify employees who were classified incorrectly may include unpaid overtime, unpaid wages, benefit expenses, unpaid vacation, missed meal breaks, and rest periods. So there is a lot of back pay that an employee may be eligible for if they're classified incorrectly, which is why it is so important to make sure that we're classifying employees correctly. And then, of course, reputation damage, which we all know how much that can hurt a company, and no one wants that. All right, so we're going to end our webinar today with a poll. So we discussed a lot of different topics, and we are soon going to be discussing our webinars for the 2023 year. I can't believe it's already coming up on us. So we want to know, what topics did we discuss today that you want to learn more about? So give me one moment. I'm going to start the poll, and you can go ahead and answer with as many of the answers that apply to you. All right, the poll should be launched, so go ahead and submit your answers. All right, a little over half of you have participated, so we're going to give it a few more seconds. Wow, this is awesome participation. Thank you, everyone. All right, I'm going to go ahead and close it, and let's see what the results are. All right, it looks like exempt versus non-exempt is still a big one, so we will definitely do our best to have a webinar that goes into that in more detail. Full-time versus part-time, seasonal and temporary, and independent contractors. All right, no one with interns and volunteers, which I find very interesting, but this is great for us. So we're going to take this back and we will use this to work on our 2023 calendar. All righty. So as always, we are here to help. We don't just like telling you a bunch of things and having you figure it out on your own. Definitely feel free to reach out to us. We can help update and create your employee handbooks and company policies, provide tools for you to utilize to determine employee classifications, including those tests we talked about, keep up with changing state and federal laws, and assist with day-to-day HR best practices, forms, policies, and more. And if you don't know, our HR Services Compliance Package also includes a learning management system that has a bunch of employee and manager trainings, including state-specific compliant harassment prevention training. All righty. Now let's see if we have any questions from our audience today. All right, I don't see any, which means we either did a great job or we overwhelmed you with a bunch of information. Either way, you can always email us at hrservices@payentry.com. We are more than happy to answer any questions you have and talk with you about our different services so that we can best assist you. Thank you so much for joining us today. In 2 weeks from today, we're going to have a common HR mishaps training during our usual scheduled time. So definitely go ahead and sign up for that on our website, www.payentry.com/webinars. And we look forward to seeing you all in a couple weeks. We hope you have a wonderful rest of your day.